Hello, hello. It says it's recording, so morning, which is good. All right, welcome, week 3, criminal law. As you can see, the information is piling up, the rules are adding up, and for some of you, it's clear as mud. So let's try to bring some clarity. The recording should be working okay. Like I said earlier, if there's a recording and you want to review something, just email me and I'll see if I can find a replacement for the 2 prior weeks. Make sure you sign that attendance sheet. If your signature is not on there, you're not here. I'm not going to be arguing with you, 4 weeks from now about whether or not you were here. I won't remember. So make sure you sign it. And a lot of you were asking if you can't remember where you sat from last week. So that's why I usually wait till now to have you fill out the seating chart. So make sure you're happy with where you are. Yes. There's nothing on the back? Oh, it didn't copy the back. You just want us to sign our names, the printer names? Yeah, well, let me see perhaps. Yeah, if you're Cornitzer to Zagazeta, you're gonna have to just sign your name. I'll make new copies. Thank you. I told the printer to make two-sided, but I guess it didn't listen. Go to modules. Right at the top should be seating chart. You click on that, it is a Google document. So you just go in there, figure out where you are on that seating chart. It has these signs, so if you're in the front, then you're putting by the podium here. You can see this side has 4 seats, this side has 6. So that's how you figure out where you are. I'm sorry? No. And then if you're in the back, you put it in there. And don't worry, name doesn't fit completely. I'll fix it later. Okay? So go ahead and fill that out. That's another way I'm going to keep track of who I'm calling on. I also have the list, but also how I get to remember your face. Okay? Because there's like 60 something of you all. Some of you I've seen before. And remember, I just got an email from someone asking for a reference, and I'm like, if all you can say is I was in your class and I got a B, I'm like, your transcript says that, right? For me to be a reference for you and say something beyond that, I gotta like have conversations with you, remember who you are, etc. So fill out that sheet so I can get to know you. And like I said with the attendance, just writing your name if it's not listed. We can keep the side conversations to a minimum. I'd appreciate that because this room, the sound is really carrying. Okay. Next week is the makeup, right? So, like I said last time, let me do student view. You're gonna go to week 4. Okay. It says it's a makeup pre-recorded video. Oh, really? With the audio? Okay. Well, I'll just let the IT know. Week 4, makeup writing assignment. You also have this IRAC writing video, right? A lot of students like, how do you want your essays? I did a whole video showing exactly how I want the essays. So watch the video. You might have to watch it multiple times because right now you're not really writing an essay. But because you're going to have a writing assignment, watch the video before you write so it can remind you. I show you exactly how I want it. So when I get to the final exam and I see people just writing it any which way, I'm flabbergasted because I'm like, I told you how I want it written. And people are like, well, why didn't I get points for this? Because you didn't write it in the way that I told you to write it. Issues, rules, analysis, and conclusions. That's how you get points on an essay. That's how you pass the bar exam. Okay, and the final exam. So this will be your opportunity to have me take a look at your writing. I don't typically give a lot of detailed feedback because it's not graded. I'll give you some general information, but if you want like it to be scored like it was a grade, then you let me know. Some students feel like they can't handle that because they don't do as well, and so that can really, you know, add to the stress. I don't want to add to your stress unnecessarily. So you let me know if you want it scored and I'll score it for you. Otherwise, I'll just mark it completed and give you information. So what I do is the hypo for week 4 is what is given to you. And I treat it like it's an essay on your final, right? So I'm giving you 2 different prompts. That doesn't mean you're writing a paragraph each. You're writing IRAC, spotting all the issues that you see, giving me the rule, analyzing that rule based on the facts, drawing a logical conclusion. Then you will upload it, or you can just put the text directly in. So there's it accepts a lot of different files. For those of you who have Apple, the doc pages, I cannot open it on my computer. So convert it to a Google Doc, just copy and paste it into a Google Doc, and then you can upload it. And then it will be scored right in there. And then there's also the pre-recorded video where I go through, there's a quiz, there's the slides, the IRAC video, recorded lecture. So you watch the lecture first, go through the slides. The lecture has little questions in it to keep you engaged, a little quiz. Again, it's just scored as completed or incomplete. So don't worry about if you're getting them right or wrong. Worry about, are you learning from the questions? Watch that video, look through the slides again, make sure you take notes, you've read the cases. Watch the IRAC video to learn how to write the essay, and then complete the writing assignment. Okay, so that should take up about 3 hours of your time to make up for the class. Any questions? Okay, it's due before the next class, and if it's not completed, -1 off your final grade because it's a required assignment. Alrighty, so we know what we're doing next week. Let's get into this week. As always, I'm going to review what we learned before we go into the new material. Week 4 has a lot of material because we're learning sexual assault, burglary, and a lot of crimes. They have a lot of parts. You got to memorize those elements and you got to know what they mean. And yes, they will be on your midterm. Good morning. So make sure that you understand them. And then when you come back in week 5, we will have review to prepare for the midterm. But that's going to be your time to ask all the questions of the things you're not understanding. So if there are things you don't understand, bring your questions, okay? And it will have that available during the review session. So go ahead, log into Slido. We're going to do some practice questions. Refresh your memory on common law homicide, because today we're going to talk about modern day homicide from the Model Penal Code, the degrees model. We're going to take a look at some of the Florida versions of homicide just for comparison, and then put it all together. Wrap up homicide. Okay, that will come up again if you didn't get a chance to catch it. So remember, with evidence, it's all admissible, whether it's direct or circumstantial. And you have to remember that when you're reading fact patterns, right? You see the facts, ask yourself, what are the reasonable inferences I can draw from the facts that are given? Do not make up new facts. Do not assume facts. Use the facts given and draw reasonable inferences. Corpus delicti, the rule requires 2 parts, death and criminal agency. Those are the 2 parts of the rule. You have to demonstrate death. You have to demonstrate criminal agency, usually death. Very straightforward. You have a dead body. Criminal agency means someone caused that to happen. It's not accidental, it's not suicidal, or natural causes. But if there's not a body, then we know that you can still establish death. Make sure you understand the difference between retributivism and utilitarianism. 2 questions on your midterm about those things. Okay, that you know what those words are that you're looking for. Guilty hand moved by the guilty mind under the required circumstances that sometimes cause a bad result in the absence of a justification or excuse. That walks you through everything we cover in criminal law. So make sure you retain that and kind of recite that every time you're reading everything. What part of that statement are we dealing with? We're still looking at mens rea, actus reus, and we're still looking at homicide. You have this memorized by now, right? Common law versions of homicide. 3 types. There's murder. 2 types, murder and manslaughter. Under murder, there are 4 types of murder. On your essay, you are writing, murder is malice plus killing every single time. I got to see that sentence. I give points for that every time on the final, and people miss those basic points. And I tell you to put it in there. Murder equals malice plus killing. That is the rule. Malice is the mens rea, killing is the actus reus. However, the mens rea has 4 forms: intent to kill, intent to do great bodily harm, depraved heart, felony murder. And so then when you talk about each one of those forms, you're going to give me their definitions, and then you're going to analyze them and draw a conclusion about whether or not the killing at issue falls into one of those categories. And then if someone intentionally kills, but they did so in the heat of passion, with as a result of legally adequate provocation, and they had no reasonable cooling off period, then there's a case for voluntary manslaughter. Whether typically they're charging murder and the defendant is asking for voluntary manslaughter, or the prosecutor is going to charge both and let the jury decide what they think happened. But you got to talk about those 3 parts. Involuntary manslaughter, right? You see that typically is accidental deaths, but it can include other types of death as well. So whenever you see a killing, if someone dies, homicide needs to be part of the discussion. And then you got to figure out which versions will best fit the facts. Okay, are you all still able to see it on the TVs? So I don't know what connection is lost. Okay, let's look at this hypothetical fact pattern. Can we charge Dan with manslaughter? That's one of the things I tell you in the video for essay writing. Read the call of the question first so that you know what you are looking for in the facts. It helps you really focus. So now we know we're looking for manslaughter. We know there's 2 kinds. There's voluntary and there's involuntary. So we're looking for either evidence of heat of passion or adequate provocation, or maybe some form of negligence that's involved. Okay? Dan is driving down the street at night, unknown to him. His taillights are out. Carla is driving behind Dan, and because his taillights are out, she did not notice that he was coming to a stop. She runs into Dan and crashes the car. Patricia, a passenger, ends up dying as a result. Driving without your taillights is a strict liability misdemeanor. We're going to talk about strict liability, but the key word here, based on what we've learned, is misdemeanor. Okay, so what do we know about misdemeanors and manslaughters? Can we charge Dan with manslaughter? See, the question is broad, so that means either kind. And if you popped in late, just make sure you sign that attendance sheet. Is it showing up for some and not others? Oh, the attendance sheet's still working its way around. It's a big class. All right, good. Was everybody able to access it? All righty. Yes. Okay, good. So yes, we can charge him. Misdemeanor manslaughter, right? That's something that came up in your readings. A killing in the course of a criminal act not amounting to a felony, for example, a misdemeanor. And misdemeanor manslaughter is just like felony murder. If you are engaged in a misdemeanor, someone dies while you're engaging in that misdemeanor, then you can be charged with involuntary manslaughter. It's just another version of involuntary manslaughter. Your decision to engage in the misdemeanor is seen as being negligent. That's how they're connected. Okay. In modern times, they have statutes that take care of all these things under the Motor Vehicle Code, but this was a way to charge people with these kind of negligent deaths while they were driving. Misdemeanor manslaughter is a form of involuntary manslaughter. If you're engaged in a misdemeanor and someone ends up dying during your misdemeanor, then you can be charged with involuntary manslaughter. Remember, in the fact pattern, it tells you he was driving without your tail lights. Working was a misdemeanor. Okay. In this class, we will learn what the felonies are. And so if you are not told something is a felony, do not assume it's a felony. Depending on what the question is asking, you may have to assume it's a misdemeanor, but don't assume that because something in modern times is a felony, that the question testing you under common law jurisdiction is also a felony. Under common law, only a few things were considered felonies because under common law, felonies were all punishable by death. Think about all the things that are felonies now, where no one's getting the death penalty for marijuana possession, right? So keep that in mind. The facts given to you and reasonable inferences. Do not make up facts, do not make up rules. So now let's look at this hypothetical. We are in the common law. Okay, so the stuff we've learned up to this so far. You're deciding whether to give the jury a manslaughter instruction. How do you rule? If no, what would be the appropriate charge? So we have Sam, who's a suicide bomber who kills 10 people and himself in a local shopping mall on Friday. Carl, who convinced Sam to commit the act, is in court at an arraignment charged with conspiracy on Tuesday. Victoria attends the arraignment and is clearly distraught. She shoots Carl 5 times, yelling, "You killed my family and everyone I love." Victoria's defense attorney seeks a manslaughter charge after her arrest for killing Carl. So everyone has the party straight. Things that you notice. They're giving you dates, or at least the days of the week, right? Ask yourself, why does that matter? The facts tell you what she's yelling while she does it, okay? Think about, if I'm defending Victoria, what basis would I have to ask for a manslaughter charge? Let's look at a couple of questions based on that. Alrighty, there's about 60 of you in the class, so I need you answering much faster. You're the judge deciding to give the manslaughter instruction. How do you rule? It's denied. Okay. You're going to say no to the manslaughter option. About 30% of you said yes. Let's keep looking. What would be the appropriate charge? Murder based on intent to kill. Didn't she intend to kill Carl? Yeah. Right? Don't overthink that. Okay. If they want the person to die, and they take the action, that is the intent to kill. Could she also be charged with involuntary manslaughter? Yes. Remember, felony murder, you got to see a felony being committed and then someone dies as a result. And so there was no felony identified in that fact pattern outside of the actual killing. And so remember that when we're doing an appropriate charge, I told you when you're in the seat of the prosecutor, you're going to go for the highest charge. If you're a judge, the same thing. It's not necessarily you go for the highest charge, but you're looking for the appropriate charge. You're going to start with the highest charge. So there's clear facts saying she wanted to kill this person. So intent to kill is going to be the form of murder. Oh, okay. Let's go back. Why is manslaughter inappropriate? Let me see here. Justine. Is there a Justine here? No. Alrighty. Let's go with Grace. Okay, good. How do you know that? Mm-hmm. Okay, so tell us the dates and why that is enough to be a cooling off period in under common law. Okay. More than a day? Yes. Okay. Okay. So we have the cooling off period, and then you're talking a little bit about heat of passion. I'm calling someone else to talk about that. Isabel. So we know that no cooling off period has to be present. Here there is a cooling off period. But what else is missing from this? Um, if she's arguing, well, me seeing Sam in court is what provoked me. So why would you say it's a cooling off when I saw him, I got provoked and I shot him right away? What is wrong with that argument? For a provocation, I'm talking about, not heat of passion. She's clearly in the heat of passion. Isn't she really upset in that moment? She's screaming, right? So we're talking about provocation. Why is the provocation not enough? What does provocation require? Good. There's 5 categories for it to be legally adequate. One of them is that you see a close family member being injured. Here, the only thing she saw was the person who caused her family member to be injured, so it's not going to be enough for the provocation either. Okay? So even when you see one thing that's obvious, that you still should go through the other elements. This is where the points are, right? Or if this was multiple choice, I wouldn't have cooling off on there because it's obvious. I would have the provocation discussion. You're like, oh shoot, what was the provocation again? Right? And you have to remember there's 5 categories. If it doesn't check one of those categories, it is not going to be enough under common law to get a manslaughter instruction. So, next hypothetical, you are the prosecutor. What homicide charge would you bring? So you see, I put you in the role of the defense attorney. I put you in the role of the judge, and I put you in the role of the prosecutor. So you have to be able to do all three because the way we're going to ask you is going to depend on the way we ask the questions will change. Okay, and your answer may change depending on which role you're playing. Robert approaches a bank teller with a gun. He never puts his finger on the trigger. He only wants to scare her. He has no intent to kill or harm. After he gets the money from the teller, he is running out and trips on the rug. The gun falls down, goes off, and the bullet strikes the teller in an artery, and she dies. So Crystal isn't here. Oh, you didn't sign? Mike, are you here? No. Okay. So let me only the people who are missing on the front. I mean, because the back didn't have it. So as long as you sign on the back, I'll count you from there. Alrighty. Everybody else got a chance to sign? Okay. So keep filling out the Robert hypo. right? Don't wait till I start announcing the answer to answer it. You will not learn that way. You've been warned. So, you're the prosecutor. What is the charge you bring? Murder. Go for the highest charge that qualifies every time. Okay? You're going to always, in your analysis, you always start with murder. Do not jump to the thing that, oh, this looks like it's something else. Always start with murder. And ask yourself, do these facts satisfy any version of murder within this jurisdiction? You have 4 versions to work through. So a lot of you saw no intent to kill or harm and thought, well, it can't be murder. But murder doesn't only have an intent to kill or harm. It has felony murder and it has depraved heart. So what type of murder here? Felony murder. You are told he is a robber. So last week, a lot of you were arguing with me about whether it was robbery. And I said, how do you know it's robbery? You don't know the rule yet. But if the facts tell you, you accept it as true. He was a robber. So that means he is engaged in robbery and therefore felony murder. Yes?
Don't assume something in modern times is a felony. Like, well, we can assume that a robbery is a felony because it's
Bark. Burglary, arson, rape, robbery, kidnapping. Those are the inherently violent felonies. That's why I tell you to memorize that. So if you see one of those things, you should automatically be thinking felony murder if someone dies. Yes? You can have both, yes. You can. But if you're a prosecutor, felony murder is going to be the easiest way for you to establish. Because he was in a robbery, someone died. You don't have to cause it. You don't have to be reckless. You don't have to prove any of those things. You have to prove 2 things. A felony was happening and someone died. And so if you're the prosecutor, you're going to go for felony murder. But depraved heart can qualify as well. Okay? I saw a hand here.
Based on the facts, how could you argue that there was depraved heart?
Because he went in with a loaded gun and he pointed it at someone. What did we say about loaded guns being pointed at people? That's always going to be reckless. Always going to be reckless. Always going to be reckless when you have loaded guns pointing at people. We're going to need more facts to maybe show that it's shocking, outrageous, but it's always going to be reckless when we have loaded guns pointed at people. Was another hand back here? You good? Okay. Any other questions? Yes.
When we're going with deciding the higher charge, we're always supposed to pick not necessarily what, if it's in the fact pattern, we should pick it. Even if we might think it might not stick or anything. It's because the fact pattern presents it, we should pick the higher charge.
But if it doesn't stick, then how do the facts present it? The facts have to support your conclusion, right? So what is it that you're asking more specifically? Depraved heart doesn't work, or felony murder doesn't work?
Where I was like, I chose felony murder, so I chose the higher charge. But I was also doing the intent to cause GBI.
Did he have an intent to cause GBI?
Because he brought a gun.
No, that doesn't show intent to cause GBI. Shooting a gun at someone shows an intent to cause great bodily injury. No.
Doesn't qualify.
No. Well, you need facts suggesting they wanted to harm the person. Okay? If they're using the gun just as a threat, but there's nothing indicating they were actually trying to harm the person, cause great bodily injury to the person, then GBI is not met. And if you look at the facts, no intent to kill or harm. Okay. Other questions? Yes. Yes. Yeah. So what I say, when start with murder, I mean in your analysis in your mind. You are issue spotting, and you're trying to figure out what crimes match these facts. Because by the time you get to the final exam, it's just going to be a long fact pattern. Bunch of things are going to be happening, and I'm going to ask you to talk about what crimes you see and what defenses you can bring. That's going to be the question. And so you see someone die, in your mind, I want you to say, is there any way to charge murder? There was a killing, so was there intent to cause great bodily injury, intent to kill, depraved heart, felony murder? Okay. Then you're going to go to manslaughter and say, does this fit either version of manslaughter? In your discussion, you're going to go through that. It's likely going to trigger one of them. That's how we test it. Okay. So it's just going to be like this. A bunch of stuff is happening. He's robbing. You're going to learn some other crimes. He's trying to take money from the bank. That's going to be another crime. There's going to be multiple crimes. right? And so it's not, we're not going to call him robber on the fact pattern. It's going to say person A comes in, tries to point, shows a gun to a teller, asks for the money. Then you have to say establish first it's robbery, and then talk about felony murder. And then other types of murder, because we're going to have more facts. So then that'll allow us to know whether or not it's shocking, outrageous, and can meet the extreme indifference to human life. But that's why felony murder works better here. We have felony, we have someone died. That's all we need. Felony murder fits. Okay? No? Okay. Alrighty. Another question. So, let me make sure you all are filling out this what is happening? Alrighty. Good. This front row, make sure you fill it out. Every seat is taken here, so someone's missing. Okay. Make sure you please go fill that out. Thank you. That's why I have to go and do a little reminder. So now you're seeing the stuff is not as simple as you thought. You thought you had it. Oh, I got the rule. And then now you're like, oh, I don't, what? This is an actual MBE question. It's been retired and they've released it through Adaptabar. And then they've even released it from they don't use it in Adaptabar anymore. So I use it in class. So you kind of understand how this is tested on the bar exam. And you might think, how am I supposed to answer questions from the bar exam already? You're not going to take criminal law again before you take the bar. This is your best time to figure out if you understand this material or not, because you will be doing this in bar prep and they'll give you 2 days to review criminal law. Okay? So you can answer these bar exam questions now based on what you've learned. Which of the following is the best theory for finding the driver guilty of murder? Oh, wait, I don't think I did it. I presented it. There we go. So, best theory for finding the driver guilty of murder. Okay, so recall what murder requires, and let's look at the facts. The driver, while intoxicated, drove his car through a playground crowded with children just to watch the children run to get out of his way. His car struck one of the children, killing her instantly. Okay, so you have a couple of options here. Read them carefully, match them to the facts, and then choose the answer you think is correct. Take your best guess. Don't spend too much time on these questions because we have a lot to get through. Because there's a lot of you, it takes a little longer for it to process. Okay, commission of an act highly dangerous to life without an intent to kill, but with disregard of the consequences. Ebony. Who's Ebony? Oh, thank you. That's why I'm like, I remember the name, but I couldn't find you. Okay. What is that a definition of? Commission of an act highly dangerous to life without an intent to kill, but with disregard of the consequences. Take a deep breath. The question asks for murder, so you know it's one of the forms of murder. So which one does that match? No, ma'am. Felony murder means felony plus killing. You have to speak way up. Think about it. Does it say anything about intent? Okay. So you know it's not the first two, and we said it's not felony murder. Which one is it? Depraved heart. An act highly dangerous to life. What is that called? Recklessness. Remember when I said you have to know these definitions? Because sometimes the answer is going to be the definition and not the name of the thing. It's going to be the definition of the thing. Act highly dangerous to life is recklessness. Without an intent to kill, but with disregard of the consequences. Conscious disregard of an act that has a great, very high risk of death or great bodily injury. That's just another way of saying that. Okay, a lot of you chose intentional killing. Did it say he intended to kill anyone? No, he did. Did he? Remember, intentional killing means you want to kill someone. The facts told you that the only reason he was doing that was to watch them run and get out of the way. I don't care if that's unlikely and it sounds stupid. That's what the facts said. You accept them as true. Okay? There was some hands. Yes.
What was confused because so like the thing you had us listen to over the week, whatever, about the causes and like that case, they were explaining that the person either talked about like should have known purpose and such.
Wait. You're talking about, you mixed up a lot of terms. You said purpose,
They
should have
talk
known.
about purpose and like what that means. Like they described the one that you had us listen to.
Purpose is model penal code. We're in common law. We're in common law. Okay. How do you know we're in common law? It's silent as to the jurisdiction, so you assume common law. What about all these people who picked felony murder? Where was the felony? Stop assuming it's a felony. I don't care if it's a felony in real life. We're in common law. There are no felonies for just driving your car recklessly. Yes.
The common law doesn't view your vehicle, driving your vehicle as a
No.
Okay. Copy that.
Remember common law? There were no vehicles. It was horse and buggy. Okay. When it formed. Common law is ancient England, colonial America. By the time we became a nation, we started writing statutes. There are statutes that say that. Stop assuming that stuff is felony unless it tells you it's a felony or it's one of these BART crimes. Yes, ma'am.
Like, make sure this is clear or my understanding. So for murder, there are two intentional types of murder. And
Correct.
Unintentional.
Not necessarily.
So depraved heart and the felony murder, doesn't matter about intent, or does it?
Right. The intent doesn't matter, but that doesn't mean they're unintentional. You can intend to kill someone and still charge them with depraved heart or felony murder. Felony murder is just easier to prove. Felony, someone died. You don't even have to kill them. Someone died. But if you intended for them to die, you can still be charged with felony murder. If you intended to harm someone, you can still be charged with depraved heart because it is reckless and shows extreme indifference to human life to be pointing guns at people and shooting towards them. Do you see what I mean? Okay. So now you're seeing why it's important, why you got to memorize the rules, their definitions, make sure you understand how they are applied to the facts. Yes?
So in this case, just to confirm, this was recklessness and depraved heart.
Depraved heart includes recklessness and extreme indifference to human life. The answer is the definition of recklessness.
Okay.
Did you have a follow-up or no?
Well, I think for me, what confused me, I tried not to interpret it, but then I did, was when the statement, just to watch the children run to get out of his way, I instead of looking at it literally, I interpreted that as a statement that was made. And if it's a statement that was made, then that could be, like, in other words, in real life, isn't it more the case that prosecutors frequently make the argument that this was not actually something that would qualify as involuntary manslaughter? This would definitely be premeditated. They would try to bring evidence and say that this person thought about it and so on and so forth.
And where are we? And in law school world. Take that real life stuff out of your head. In law school world, you accept the facts as true. In the real world, people make arguments to a jury or a judge. I'm not asking you to make arguments to anyone. I'm asking you to accept the facts as true and apply the law that is given to you, and then draw a logical conclusion. Okay? So you got to stop doing that. You'll get plenty of opportunities to go in real life. Go be a CLI, go do an internship, go become a prosecutor or defense attorney or a judge, and do all that stuff. But you don't get to get there if you don't get this first. Because in real life too, you're not going to like what the law says every now and then. You're going to disagree with it, and you're going to have to make the arguments anyway. You're not going to like that these facts fit this felony when really this should be a misdemeanor. But there you are in the prosecutor's office, and your boss says charge it as a felony. Okay? So you have to learn to apply the facts to the law and draw a conclusion. Once you do that, you can start getting creative depending on what your goal is. But you got to stop all that in real life stuff. We're in law school world. On the midterm, on the final exam, on the bar exam, you're going to stay in law school world. All right? Any other questions? Okay, I think you all got it now. You got it. And if you didn't know that this first one was recklessness, you better go memorize that definition again. Alrighty, let's look at this video. Hopefully it plays. This is, again, more review, ripped from the headlines review. So now we're using real life. The facts are from real life. You're still going to accept them as true, but I'm going to ask you to apply common law principles to these facts to answer the questions. And every now and then I ask you for your opinion or how do you think something should turn out so that you can get that out of your system. Okay? Because you notice I don't stand up here giving you my opinion. Nobody cares. Okay? Kind of have to get over that. Nobody cares about your opinion. We want to know what your analysis is. And then once you kind of stop taking that personally, this gets a lot easier. This is an actual case, grandfather charged in granddaughter's cruise ship death. Okay?
Now to our exclusive interview with Salvatore Sam Anello, the grandfather accused of negligent homicide in the death of his granddaughter, Chloe Wiegand. The 18-month-old fell 150 feet from a Royal Caribbean cruise ship docked in Puerto Rico. Anello was holding the girl up against what he thought was a bank of closed windows when she slipped fast. Lead national correspondent David Begnaud sat down with Anello in his first interview since the incident. David, how is he handling this?
Anthony, he seemed emotionally numb when we met him yesterday. He told us the reason he wanted to do this interview was to try and plead with Royal Caribbean Cruise Line signs up when and where they actually have windows open on the ship. We wanted to do the interview to better understand exactly what happened. This grandfather is facing 3 years in prison because prosecutors believe his actions on the ship were reckless.
The process by which he slipped, how did that happen?
All I know is I was trying to reach the glass, and I know that we leaned over to try to have her reach the glass, and at that point she slipped.
She slipped. But at that moment, did you realize there was no glass?
I didn't realize there wasn't any glass till absolutely it was too late. I mean, even when she first fell, I thought she fell in front of me. I thought she fell in front of me.
What was your reaction when you found out that you were the subject of this criminal investigation?
Being gone is the worst thing ever, so I'm like, whatever, you know. I don't know what to...
Help me understand what you mean.
There's nothing worse that they can do to me than what's already happened.
We are going to have more of our exclusive interview with Salvatore Sam Anello in our next half hour. He's going to talk about the health condition he says he has that may have played a role in the tragedy. Plus, we have new details about that surveillance video. Shows the final moments leading up to what happened.
So
so difficult, the details, and none of it changes the fact that I feel like 3 years is a lot to put on top of somebody who's already
Okay, so
suffering.
you heard those facts.
David, thank you very much.
They decided to do a criminal investigation. What crime should he be charged with, if any? Yes.
Why would somebody want to do an interview in that situation?
I don't know. He did. No, it's not about the defense. It might be about letting the cruise ships know that this is a risk that they need to address. Yeah, but you know, I don't have information as to why he decided to do that. But if you watch the rest of the interview, you might hear why he decided to do the interview. Alrighty. Good. Remember, misdemeanor manslaughter is a form of involuntary manslaughter. A couple of people said murder. I don't know if there's enough for extreme indifference to human life here, given what he's described. Hold on, we still got some more questions for this one, and then I'll answer your question before our break. So if the prosecutor decided that the grandfather's behavior was merely reckless, what could he be charged with in a MPC, that is Model Penal Code jurisdiction? We are switching jurisdictions. You have been told which jurisdiction to apply, so now you have to look at those options, take out any of the ones that are not Model Penal Code, and then decide what he would be charged with. All right, you all going a lot slower. So Model Penal Code jurisdiction has different names for their crimes and different requirements. The key here was merely reckless, right? So that is going to be negligence under Model Penal Code. Model Penal Code does not have a category called involuntary manslaughter. You got to memorize these terms. Yes, ma'am. Your question.
My question? Oh, okay. Yeah, because I was trying to decide when, so for common law, when you ask what crime, is it only involuntary manslaughter, felony murder, and murder?
No, the two categories are murder and manslaughter.
Murder and
There's two kinds of manslaughter, voluntary and involuntary. There's 4 kinds of murder.
Okay.
So if I ask you what crime in common law, like I said, we're going to learn a lot more crimes. It means all crimes that may apply to these facts. So far, we've only learned homicide, so that's the only ones I can test you on. Okay? Yes?
The MPC negligent homicide is the same thing.
Right. It requires criminal negligence. Yep. Again, the definition is the option, not the name of it. So a lot of you are like, how is this not involuntary manslaughter? It would be if we were in common law jurisdiction. Model Penal Code does not have involuntary manslaughter. It only has one form of manslaughter. Okay? Manslaughter under Model Penal Code requires either extreme mental emotional distress or recklessness plus or recklessness And then murder has 3 categories: purposeful. Wow, my brain just went blank. Has the 3 kinds. Woo. We'll go over it in the next hour. Reckless plus, purposeful, or knowingly. Thank you, because I'm like, it has with certainty of death, knowingly. So this is clearly within this kind of unintentional negligence death. It's his granddaughter. He's not trying to hurt her. He didn't know that the window was open. I don't know if you've ever been on these cruise ships with these huge windows, and she just it's clearly an accident. And so if we're talking about accidental death, it's going to have to fall into some negligence territory. He knew or should have known there was a risk. Remember, when the victim is younger, right, the risks are higher. And this was a baby. Okay, so he probably was not charged with some form of murder even in real life. All right, let me see if there's any Q&A before we take our break. Okay, I don't think so. Make sure you fill out this form if you have not done so. This does not look like 62 names on here, but I haven't counted. Do that during the break. I'll see you guys in 10 minutes. We went to the same college in New York. So he's been a great alum and would come visit and everything. Let's see, we spent a lot of time on see if we have some more time for you. A lot of you had a lot of great questions about the readings. We're going to be going over that in this second hour. Okay, what is it that you need to know from the Model Penal Code? What are the differences? That is what we're going to be covering. If you're going to do remember, there's a hypo every week. If you want to practice writing essays, just write out the hypothetical fact pattern after class, not before, because I found when people do it before, they miss a lot of things, right? We're going to add some clarification. All you have to do is email it to me and I'll respond. Okay, yeah, this video, we'll skip that one. Okay, a judge sentencing a young girl after she pleads guilty to manslaughter says, "I don't care what message this sends to society. I will punish you with the harshest sentence for killing your sibling. It was despicable, and you deserve the harshest punishment for committing such a vile act." So even though we didn't watch the video, you have the facts to figure out which theory of punishment is this judge using. All right, retributivist. Don't care what message it sends to society, right? Utilitarians care about the message to society. Harshest sentence, despicable, you deserve. That is retributivist theory. Okay, so people have asked, what do the questions look like on the midterm? They're going to look something like this when it comes to the theories. They're also going to look like the questions in your Swedlow book, right? A fact pattern is given. It's going to ask you to answer some aspect of the crime. It's not just going to say, which crime is this, right? It's going to require you to analyze what crime it is and whether or not something is missing or all things are met. This one is very sad. So we're going to skip it because we don't have much time. But you can watch it in the slides if you want and do some issue spotting about the different things that are happening. Let me go to... But this is another real life case that I turn into a fact pattern to test your understanding of common law. Are there any other questions about common law before we go into Model Penal Code? So I gave you that chart. You got to memorize it. A lot of you are asking, like, how many forms of murder? That's what that chart was for. And as we add to the chart will change. You should have some kind of chart. Common law has 2 types of homicide, murder and manslaughter. Murder has 4 types. Manslaughter has 2 types. Okay? You got to get that straight. What do you talk about in an essay? All of them. If it's clearly not an intentional act, real quick sentence. Wasn't intentional, so it's not intent to kill, intent to cause great bodily injury, and then move on to the other ones. If it was intentional, then talk about what fact shows that it's intentional. Okay? So, unlawful killing of a human being by another without justification or excuse. What happened to the common law? It became statutes, just like I said. A lot of people are like, how come there's not vehicle things in common law? Because there weren't vehicles. It's a really old judge-made laws. Judges usually used to get on horseback and go to different communities and try to resolve disputes. And then they would keep track of it in books and talk to each other, right? That's why they're called circuits. They literally would go in a circuit and go town to town. That became very inefficient as we grew as a nation. America was one of the fastest growing nations when it first came along. So we're like, oh, we got to get this stuff organized. They turned them into statutes. So they start having all these statutes. Some of it adopted common law language, some of it departed from it. And then, even after all these statutes, they saw from state to state, everything was kind of different. Depending on what state you lived in, you could be charged with completely different things and get different punishments, even though you're engaging in the same acts. And so a bunch of people got together, created what's called the Model Penal Code, MPC. It is not the law in any jurisdiction. It's just like how we test common law, right? This is not what the law is in anywhere. It's one set of laws written down as a model, perfect. If we could have all the laws be the same, this is what we suggest, Model Penal Code. That's why they like to use it in law school world, right? So we're using law school rules. However, some states took pieces of it, just like they took pieces of common law, they took pieces of Model Penal Code. So when you're reading your cases, that's why they say we're adopting this version or we're interpreting this version. Or in the common law, this is how it worked, and we're going to interpret our statute to match the common law. Or in the common law, this is how it worked. We don't like that, so we're going to interpret our statute in a different way. But when we read the cases, we're trying to compare it to how would this apply in common law? How would it apply under the Model Penal Code? Okay? So, before we get to Model Penal Code, at Cooley, we like to teach the degrees model. They do like to test it on the bar exam. They will tell you that, someone's charged with murder in the first degree or second degree. A lot of people have heard those terms. Again, we're using the terms for law school world, not how it works in the real world. Okay? For when it comes to homicide, and specifically murder, degrees was a way to categorize the seriousness of the crime to match it with the correct severity of punishment. So a place like Florida that has the death penalty requires you to have first-degree murder before you can give someone a death penalty, or second-degree murder. And then they define what counts as first-degree or second-degree. At common law, all felonies were punishable by death. So they wanted to make sure it was the worst crimes. That's why everything's not a felony. Most of the crimes we study in this class under the common law are felonies with a few exceptions, and I'll tell you which ones are not. The BARK crimes, B-A-R-R-K, burglary, arson, rape, robbery, kidnapping, were considered the inherently dangerous crimes at common law. And that's why I tell you to focus on those for purposes of the class. But the common law said all felonies counted for felony murder, and they were all punishable by death. The degrees model applies to murder, not manslaughter. Most states, if they have a degrees model, they create some different forms of manslaughter between voluntary and involuntary by statute. For purposes of this class, your midterm, your final exam, and the bar exam, first degree murder is going to be defined as, don't get lost in this. This is just common law how it looked. But this is the rule that you will use. This is the rule that needs to be in your outline. This is the rule you will be tested on. You need 3 things in order for something, a homicide to count as first-degree murder. It has to be willful, same as intentional, same meaning, just a different word. It has to be deliberate. Deliberate doesn't mean on purpose. Why not just say purposeful? I don't know, because I didn't make up the rule. I want you to see this word as deliberate, the way a jury deliberates, meaning you had time to think about what you were going to do. Deliberate in this setting is the opposite of heat of passion. So the heat of passion is you're so upset you lose your mind. Deliberate means you're in a cool state of mind and you're able to give careful thought and weighing of considerations for and against whether you want to kill that person. So deliberate is about the person's state of mind while they are engaging in the killing. Remember, it is a willful, which means intentional. You have a cool state of mind. And premeditated means that you considered the killing before you did the killing. But just like cooling off period, there's no exact measure. It could be 1 second before you kill the person. It could be 1 year. So premeditated doesn't mean they had some elaborate plan. They just looked at that person and said, I want to kill you, then killed them. And they weren't in the heat of passion. They were in a cool state of mind. Okay? So first degree murder is willful, deliberate, premeditated. So if you are in a quote-unquote degrees model, the question somehow implies or outright says you're in a degrees model or a modern jurisdiction, you are looking for first-degree murder. If no first-degree murder is there, then the rest of the homicides are going to be the same categories as common law. This is known as second-degree murder. It is the same as common law. So if you're in a degrees jurisdiction, all you have to do is remember that it has one extra category, and that is first degree. Okay? So if you see someone is killing intentionally, but they don't premeditate, they're not in a cool state of mind, then you know it's going to be second degree murder. Then of course you have the other kinds that we talked about, depraved heart, intent to do great bodily injury, and felonies not listed in the first degree. So sometimes they'll say here in this jurisdiction, first degree murder is willful, deliberate, and premeditated. And, for example, burglary, arson, rape, robbery, kidnapping, then you know that all other forms of murder are going to be second degree. Again, the reason they do this is because they punish the first degree ones more harshly. They think it's worse. Capital murder means punishable by death. Only some jurisdictions like Florida have capital murder, and it usually involves first-degree murder with aggravation. For example, if you kill a judge, a witness, an on-duty police officer, multiple killings, mass shootings, killing for hire, those are just examples. That's not a rule. Just know that that's usually how jurisdictions will differentiate first-degree versus second-degree. And for purposes of this class, we don't have third degree. Now, when we're going to look at some of the laws in Florida, students get confused. They'll see something like a felony of the first degree, and they think that means first degree murder. It's not the same thing. Other crimes are also broken down by degree within modern laws on the midterm, the final exam, and the bar exam. If I'm testing you on a law that's not common law, I will give you the law. Okay? And then I will ask you to interpret that law based on the principles we've learned to come up with an answer. Especially on the bar exam, right? They like to do that. They say, in this jurisdiction, they have this law. And they give you the law, and then they ask you to interpret it. We'll practice those questions in class as well. Any questions about first-degree murder? Or the degrees model. So it's called degrees model, modern jurisdiction. You'll see first degree, second degree, those kinds of things will indicate that is a jurisdiction the question is asking you about. Now let's talk about Model Penal Code, also referred to as MPC for short. Okay, 3 kinds of murder. Common law has 4 kinds of murder. Degrees jurisdiction has 5 kinds of murder. MPC has 3 kinds of murder. So you got to keep that straight. Students get so lost in this. But if you just remember that there are different kinds and the amount that there are, then you can quickly in your mind, once you establish, okay, I'm in this jurisdiction, what are the types? Do the facts fit any of these types? 3 types of murder, Model Penal Code. Purposely, same as intentionally. They're just using a different word. You engage in conduct with the conscious objective of causing the death of another. That's the definition of intentional killing. Okay. Knowingly is the weird one. You engage in conduct with knowledge that death of another was practically certain to result. So you're not necessarily intending to kill the person, but essentially this is kind of like intent to cause great bodily injury. You're doing something that really good chance is going to lead to the person's death, even though you're not necessarily intending to kill them. Recklessly plus. Plus means is the extreme indifference to human life. This is the same as depraved heart. Felony murder will also fit into this. If you see a type of felony murder, it's considered recklessly plus in model penal code. Okay, so again, this is a lot of the stuff you already learned. They're just put in different categories, given different names. You just got to memorize it. Okay, so recklessly plus extreme indifference, which is depraved heart. Felony murder will also fit in there. The reason why I say recklessly plus is because under manslaughter, they have something called reckless, right? So we're going to keep that straight. And again, model penal code does not use the term felony murder. They place it under recklessness plus because they're saying if you're committing one of these felonies, we presume you are acting recklessly with extreme indifference to human life. And they add escape as one of the crimes that are inherently dangerous felonies. So you can use Barker there, Breaker, whatever helps you remember it. This is less important under MPC than it is under common law. Okay. You are presumed to be reckless with extreme indifference to human life if you engage in a felony. And so you will be charged with recklessly plus murder. Model Penal Code manslaughter has two kinds. It is manslaughter if you are merely reckless. So that means you don't need the extreme indifference to human life. But remember, recklessness is still a conscious disregard of a high risk of death or great bodily injury. You have to know of the risk and ignore it. And you're looking for facts to suggest that this person knew that this was really risky. And again, objective standard. And then they did it anyway. Or the homicide, which would otherwise be murder, but you're under the influence of extreme mental or emotional disturbance, which is shortened with EMED, for which there is a reasonable explanation or excuse. So you need both parts. You need the EMED, and there has to be a reasonable explanation or excuse for why you have the EMED. This is similar to heat of passion, but there's a lot of differences. You will be tested on those differences. So make sure you know the difference between voluntary manslaughter under common law and MPC manslaughter. So what is extreme mental or emotional disturbance? This concept is intended to incorporate the two common law doctrines of heat of passion and diminished capacity. Okay? The fact that you are provoked, right? The provocation now is the reasonable explanation or excuse. And the heat of passion becomes this extreme mental or emotional disturbance. It is much broader than the common law, right? Because you had those 5 fixed categories that we talked about during the review session. A lot of people are like, well, you know, maybe back in the day those were the 5 things, but there's a lot more things now. And we have a much better recognition of like mental illness. And so that some people are more easily provoked than others. So under the model penal code, if we're doing extreme mental emotional distress version of manslaughter, here are 5 differences from the common law. First, you don't need a specific provocative act. So there's no fixed categories, right? Like 3, that's the same thing. Well, similar. Let's say with no specific provocative act. It could just be generally you're having a hard time with mental distress or emotional distress. And as long as we can identify that you are in that state at the time of the killing, the EMED can be satisfied. Under model penal code, the provocation can come from anyone. Under common law, it had to be the victim who provoked you in order for it to count. But you read one of those cases, someone else provoked them and they killed a third party. And they're like, under the model penal code version, that is okay. Under common law, that person who provokes you has to be the victim. There's no fixed category of provocation, so it doesn't have to be specific things. It can be anything that provoked you. Words alone are enough under the model penal code. Mere words are not enough for common law. It can't just be words, right? You have to actually see things or be engaged or be attacked. So if all that's involved is words that you heard someone say, under model penal code, that could be enough. So those cases where we had those two gentlemen, they combined their cases because their wives were saying they were cheating on them and calling them all these names and questioning their manhood, and they're like, they just lost it after that, after years of cheating and this, that, and the other. In those cases, if they were in a model penal code jurisdiction, they could have gotten a manslaughter instruction because words are enough. And there is no rigid cooling off period. So it doesn't have to be a day or a few hours. It can be a longer time period, but the court is going to apply a reasonableness standard to how long that person may have had to cool off before they engaged in the killing. Okay? So 5 differences. You are tested on these. Make sure you know them. You can give a listen to this. This is a constitutional law case, Patterson versus New York. You start, it's about 7 minutes. I think this person does a pretty good job of explaining what EMED looks like under model penal code as they're arguing their appellate case. Won't spend time on it today, but just know that it's there. And then under model penal code, the lowest form of homicide is negligent homicide, which requires criminal negligence. Pretty much the same as involuntary manslaughter, it's just a different name. Okay. You're looking for the person knew or should have known of a substantial risk of death or great bodily injury, gross deviation. It's the same. They're using slightly different terms. When it's tested, you're looking for the same things. Okay. Are there any questions about manslaughter or negligent homicide? Yes, ma'am.
For the negligent criminal period, does the provocation then not have to happen in the moment?
Correct. So the question was, does the provocation not have to happen in the moment like common law? And the answer is yes. There's a longer period of time between when the person is provoked and when they do the killing for them to qualify for EMED manslaughter under model penal code. Yes? Yeah, all of this is going to be reasonable person. The court is going to apply what was reasonable under these circumstances. If it's like months, that's not going to be reasonable. Okay. We also had the fact pattern. Did we have that fact pattern with the father hearing from the daughter that the uncle is the grandfather? Yeah. So those are only words. He didn't actually see it. And it was months later. That's a case where the court might find that that's reasonable because he just found out. So that's what provoked them. Okay. So that's one of the differences. So if you are a defendant, and you get to choose what jurisdiction you're going to be in, you're going to want the model penal code jurisdiction because you get a lot more flexibility in trying to make an argument for manslaughter. Yes?
I'm sorry, with the Walmer, if it was on the model penal code, they could argue EMED, right? Because that was my issue at the full law.
Right. That was one of the issues, but yeah, it would be easier to make that argument under a model penal code jurisdiction. Other questions? Yes.
About the felony murder or model penal code, that falls under, is it its own or it falls under the reckless?
Falls underneath recklessness plus. Okay. This is why it's important you have to pay attention to what jurisdiction you are in when you are doing a question. Okay, and you will be told, it's not going to be a secret. If it's silent as to the jurisdiction, you assume common law. If they tell you this jurisdiction follows the model penal code, then you know, okay, different set of rules that I need to apply. Although you're looking for a lot of the same things, you have to use the right terms and definitions. Yes?
When you were talking about criminal negligence, did you say it has to have parentheses and oh.
No.
Oh,
Manslaughter has recklessness or EMED. Okay, negligent homicide just has criminal negligence. All right. So, the weird thing about adequate provocation is it's really asking when is it reasonable for a reasonable person to act unreasonably, right? It's a tricky question. That's why under the model penal code, they're like, well, if we just say these are only categories when we think the average reasonable person will act unreasonably, we think it's too rigid. But in the model penal code, because it's not rigid, this is the question you're really asking, right? What is enough to really provoke you to kill another individual? So it can be tricky, but reasonableness is always going to be the standard. And that's why we read the cases to figure it out. What have the court said has been reasonable? I used to go through a whole thing with evaluating statutes because a lot of the criminal law now is statutory. A lot of the cases you're going to read are quoting statutes, and we don't really cover that in the class. You have LegReg to kind of help you with statutory interpretation. But again, when you're tested, sometimes you're given a statute and asked to interpret it. So you got to make sure you are reading it carefully. And versus or makes a difference, right? Especially when we're looking at elements. And means you need all of them, or means you need one or the other. Just like modern penal code manslaughter says you can either have EMED or recklessness. So if you can satisfy either one of those, you can have manslaughter under a model penal code jurisdiction. Murder under common law has 4 types. It's or. As long as you meet one of them, you can charge with murder. Voluntary manslaughter in common law is and. You got to show all 3. Okay. May versus shall. Required versus some discretion. If, then, upon, before, thereafter, etc. All these terms, make sure you're looking out for them in the statutes. Also, be careful with them in the questions that are asked. One of the ways they test your understanding, they might use words like always or never. So you really have to sit down and evaluate. Does this always apply with this rule? Or is there never a situation when it can apply? Let's look at Florida statutes. Again, no, you don't have to memorize it. If I test you on it, I will give it to you. Okay? It's just real quick so we can see how first-degree murder works. In Florida, Section 782.04, unlawful killing of a human being when perpetrated from a premeditated design, committed by a person engaged in the perpetration of, and then they have a list of different crimes. So this is their version of felony murder, and it's certain types of felonies. It was really long, so I just put, predicate act, predicate substances. And in Florida, they do add certain drugs as well. That puts you in murder in the first degree. Okay? And it's a capital felony. So you can be put to death if found guilty and duly convicted. This is usually how it works. They lay it all out, right? Common law was really confusing because it's like, well, we got to look all through all the cases and say, has this been a thing in the past? A lot of these substances are really new. There weren't all these drug types in common law. And so as things change, they can adapt the statute, right? I mean, something like fentanyl may not even have existed, methamphetamine, all these new drugs. But once they start causing serious death, a lot of crime, they adjust the statute to include those kinds of substances. Florida is very strict with its felonies, and especially with murder. So there'll be other jurisdictions that don't have these drugs included. But this is why it helps, because now if we're going to put someone to death, the prosecutor knows, okay, if I charge one of these things, they might be put to death. So I need to be careful about what I charge. I need to make sure there really is enough evidence here. And when someone is facing death penalty, they're going to appeal it. This thing's going to be years, right? It's like it can be 10, 20 years before someone is actually executed after they're duly convicted. So that helps make them make prosecutorial discretionary decisions. This is how they show murder in the second. No premeditated design is murder in the second degree. But look here, it says felony of the first degree. That is different than saying murder in the first degree, like we saw on the last slide. So just make sure you're paying attention to the language in the statute. That's part of what we're testing you on. As a lawyer now, that's what you got to do. You just got to go through some statutes and figure out, what am I going to charge? When I was a CLI at the prosecutor's office, they'll just have a set of facts. They're like, see what crimes match this. And I had to go through section by section and make sure we're able to check every box before we charge someone with that crime. So that's part of the skills you're going to be tested on as a law student as well. They also have some other versions, right? Subsection 1, 2, 3, 4. And in Florida, they have murder in the third degree as well. We don't typically test you on that, so keep that in mind. This is their version of manslaughter. So after they've laid out all the things that count as murder, now they're telling you what counts as manslaughter. Here they involve killing a human being by act procurement. That means if you hire someone to kill another person, etc. Then they killing of an officer, firefighter, emergency medical tech, paramedic, right? And so they're adding different things that are called aggravating circumstances to define manslaughter. Okay, aggravating means things that make it worse. Culpable negligence is a way of saying we feel like this person is morally responsible. Here's the vehicular homicide. For all of you dying for the laws about all these people killing folks with a car. Okay, this is what it looks like. They had to create statutes. Caused by the operation of a motor vehicle by another in a reckless manner. It's usually uses some kind of recklessness under common law. If you see someone dying with a car, and there's no statute, then you're probably looking for reckless or negligence behavior in the use of that car, unless it's intentional. You can't intentionally kill someone with a car. You can't intentionally run them over and things like that. So it's not automatically recklessness, but those are the kinds of things you'll be looking for. Okay. Any other questions? Let's see what we had here. Before we go into the cases, I do have an opinion poll in here for you guys too, so you can finally give your opinion if you have a strong one. We're good? Okay. So let's talk about Murray versus State. What is the relationship between knowledge and risk? So in this case, you have Donald Murray, extensive experience with a wide variety of guns. He fired multiple shots in the victim's direction, including several shots aimed at the victim's feet. There's lots of rocks in the area. One of the bullets from the gun ricochets off a rock, severed the victim's femoral artery and femoral vein, suffered a bullet wound in the buttocks, died later that night from his wounds. We have a lot of cases where people get shot in the butt, but there's a lot of arteries there, big muscle group, and people die from that, right? So again, although we might look at when someone is pointing loaded guns, shooting towards people, we know that's recklessness. Based on all these cases we've read that show that, sometimes we have to look at what is the relationship between their knowledge and their risk. Here, the prosecutor, includes involuntary manslaughter, and he's convicted with that. There might have been a case for some version of depraved heart, but the conviction is with involuntary manslaughter. But he appealed, and he said at most the evidence supported a conviction of criminally negligent homicide, not involuntary manslaughter. So that means in this jurisdiction, involuntary manslaughter was a higher charge than criminally negligent homicide. And the court ended up affirming it, and they said that the difference between the minimum required mens rea of recklessness for manslaughter and criminal negligence for negligent homicide is simply whether the defendant was aware but consciously disregarded substantial risk the result would happen, or was unaware but ought to have been aware of a substantial risk the result would happen. In this jurisdiction, the recklessness got him to involuntary manslaughter, and the negligence got him to criminal negligence. He's trying to get down to criminal negligence to have less punishment, and the court was saying, we're looking for facts that you knew that this was a risk and you just ignored it. And they looked at the fact that this person had a lot of experience with a lot of different guns. So as someone who shoots guns regularly, who shoots at this person multiple times, in a place that was rocky and knew bullets could ricochet, he knew the risk and he ignored it. And so recklessness is the standard that was met in his case. Okay? So remember that there's a spectrum when it comes to these risks. Knew or should have known is negligence. Knew it and ignored it is recklessness. Okay? Then when you add extreme indifference to it, you're at depraved heart. Okay? Or recklessness plus. So you're really looking at what did the person know at the time about the risk they were engaging in. And then once you determine what they knew, then you can decide which category they fall into. And once you know which category they fall into, you can decide what to charge them. And students like to just jump to the first obvious thing, but you gotta go through the analysis. That is what you're learning in law school. What was their knowledge about the risk, and therefore were they negligent or reckless based on their knowledge about the risks involved? This is yet another example where a court is saying, yep, shooting guns at people is reckless. Okay, so at least you're going to get to recklessness. In the model penal code, that'll get you to manslaughter. And if you're trying to get to murder, you're looking for that extreme indifference to human life, shocking, outrageous behavior. I think this was justified here in this case, but for whatever reason, that's not what he was convicted of. State versus Beer is another case where we're examining negligent homicide. Here, the wife died, the defendant's wife died from a gunshot, which occurred after the defendant grabbed or slapped, it wasn't clear, the testimony kind of went both ways, grabbed or slapped the gun. She pointed at her head to redirect its aim, right? So they're saying here, the defendant and his wife are arguing, they're both under the influence of alcohol. He attempts to leave his bedroom, the wife blocked the way. Defendant pulled a gun from its holster, cocked it, and threw it on the bed. Why? Why? I don't know. Right? So if he cocked it, I assume it had a bullet in it. And he knew there was a bullet in it because he wouldn't have cocked it otherwise unless he was trying to scare her. But it's a reasonable inference. If you take out a gun and cock it, you must know that there's a bullet in it. We can presume that. The wife grabs the gun, points it at her own head. He grabbed and slapped the gun in an effort to redirect its aim. It goes off and she dies from the bullet wound. So he's kind of like, wait a minute. I was trying to save her life. How am I the one being negligent here? Because you pulled out the gun and cocked it in the first place and put it within reach of her. Okay? He's arguing that he did not act with the conscious disregard of his wife's life and appeals it. And the court says, no, we can affirm this because negligent homicide resulting from a defendant's failure to perceive a substantial risk, and it's a gross deviation from the standard of care that a reasonable person would have in that situation, is met under these facts. Okay? So he knew or should have known that pulling out this gun, cocking it, and put it in the bed within the reach of his wife, who he's arguing with when they're both drunk, is going to cause a risk of death or great bodily injury. A reasonable person would have perceived that risk. He didn't. He deviated from the standard of care, and therefore that is enough for criminal negligence. Okay? Questions about that? So even though we have a loaded gun in this case, it was about negligent homicide. Again, the prosecutors might have made a decision to charge it. The jury might have ultimately found negligent homicide as opposed to the other kinds. But this does satisfy it here. So there are some felony murder limitations. Write these down. Write down the definition. You will be tested on it. Students are always like, you talked about this. I'm like, it's on the slide, and I said to write it down. Okay? Write it down. Under common law, felony murder did not have limitations. Felony, person died, felony murder. Good to go. It's a really easy way to charge felony murder, and so over time they said we don't want prosecutors abusing this power of charging people with felony murder because they were using it a lot. And if you're trying to, convict a lot of people, put people away, this is an easy way to do it. So we're going to create these limitations. So if you're being tested on a felony murder limitation, you'll be told this jurisdiction has adopted one of these limitations. If you're not told that, you assume they don't apply. Felony death equals felony murder. The first one is Aaron rule. Comes from a case called Aaron. It's a minority position. Only a couple of states have it. Michigan is one of them. That's why we cover it. Aaron rule basically makes it so that you cannot just do felony murder. You have to show that the person had an independent desire to kill the person. That's why it's the minority. It's like, well, why? Then you just took all the teeth out of felony murder. Why bother? But Michigan has put that in there. The Mayle rule comes from the Mayle case, M-A-Y-L-E. It limits the felony murder to cases where the person dies during the commission of the felony. Because the rule is attempted commission or commission, right? And the person could die of anything. And so they're like, let's limit it to the actual commission of the felony instead of it just being so wide open. Because a felony could be occurring for a long period of time. Lots of things can happen. What if someone dies of a heart attack later after you leave? And they're like, well, that shouldn't really count. So during the commission of the felony is the limitation under the Mayle rule. The third rule is the merger rule or the independent felony doctrine. So it can go by either name and you can be tested with either name. The merger doctrine or the independent felony doctrine. It says that if the underlying felony that's being committed when the person dies led directly to the death, then you cannot charge felony murder. If the underlying felony led directly to the death, you cannot charge felony murder. What do we mean? Well, manslaughter is a felony. If you committed manslaughter and someone died, that's felony and someone died. And so they would try to get, instead of charging manslaughter, they'd charge felony murder. So they're saying you can't do that. If you're in a jurisdiction where aggravated assault, aggravated battery, other crimes, you're told it's a felony. But those kinds of crimes are very dangerous or meant to inflict harm on somebody else. So it leads directly to death, right? So you beat someone with a baseball bat. Aggravated battery is considered a felony in that jurisdiction. So you can charge felony murder. And in this jurisdiction that adopts merger to independent felony doctrine is saying, we don't like that. That's not a proper way to charge felony murder. So you cannot charge felony murder. You'd have to find another type of murder to use. It's a little confusing. We will have more examples and practice that. The inherently dangerous felony rule, that's BARC. Burglar, arson, rape, robbery, kidnapping at common law were considered inherently dangerous felonies. So in this class, we use the inherent dangerous felony rule. Remember, at common law, all felonies counted. And the last felony murder limitation is called the agency theory. The agency theory, one of the agents of the felony, right? The co-felons, people committing felonies together. One of them has to do the killing before you can charge felony murder. That's the agency theory. So you're thinking of an agent of the crime has to do the killing. Under common law, anyone can do the killing, and they will charge one of the felons. So you walk in to commit a theft in the bank. You and your one partner is pointing a gun at the guard and at the rest of the people in the bank. You're at the teller window asking for the money. The guard pulls out the gun, kills some customer. Those two co-felons get charged with murder, even though none of them did the killing. Agency theory would not allow that. Okay? Questions on these limitations? Yes.
The BARC
It's not Barker with the escape, it's just Barker on that one.
Right, because we're if you're applying common law, it's going to be Bark. It was just an example. Barker would be example under Model Penal Code. Yes.
So, we talked about the second one regarding information on felony. So say, like, earlier you said you made robber, he robbed, and so when he walks out of the door, someone dies of a heart attack. Is the felony still going on since he's no longer in the building, or when is the felony technically stop?
Yeah, that's a good question. Typically, a felony is considered complete when the felons reach a place of safety. So say they get in a getaway car, drive away. That's the end of the commission of the felony. Okay. These are the most tested ones: the merger doctrine or the independent felony doctrine, and the agency theory. Remember, Aaron's minority. Don't worry about that. Okay. That's not going to be really tested, especially on the bar exam. We're gonna male case, I think, was in your text, but the agency theory, merger doctrine gets tested a lot. Under the Contreras versus State case, they talked about this residual clause. So sometimes in statutes they have this kind of catch-all language. Any other felony clearly dangerous to human life. So this is a jurisdiction that had felony murder, listed a bunch of felonies that they considered dangerous, but then they put in this catch-all phrase at the end. And so the court is trying to figure out, is this constitutional? Because that sounds kind of vague. How do we know what any other felony clearly dangerous to human life means? Here, it involved aggravated child abuse of a victim under 14 years old, and the court said we consider that to be clearly dangerous to human life. They argued it was unconstitutionally vague, and the court ultimately held up that this was not unconstitutionally vague because there's a long history in the common law of what felony murder looks like and what they've considered clearly dangerous to human life. So if you see other felony clearly dangerous to human life or other residual clauses, catch-all phrases, just know that they're considered constitutional and to give notice to individuals who are engaged in that behavior. State versus Mayo has that during the commission of a felony limitation. So just like someone asked, when does the felony end? It ends when the person reaches a place of safety. Here we have a killing that occurred during the commission of a robbery. The robbery was committed 6 minutes before the person died, and the robbers had not yet reached a place of safety. The distance between the scene of the robbery and the killing was only 2 miles. And so here they said we would consider that to still be part of the commission of the felony. They used a statute out of Virginia, which listed all the different ways you can charge murder. It included commission or attempt, and they were actually robbing a McDonald's. I'm like, I guess this was back in the day when McDonald's carried a lot of cash. It's 1987, so they got the money, got out of the safe, got into a stolen car, and they were later caught trying to break into another gas station. So they were just on a robbery spree, but the court was trying to figure out, the person died like 6 minutes after. Is that enough? Yeah, it's a flexible standard. But if it was like the next day, if they got hospitalized, took a while for them to die, that's likely to be too long. So that's the male limitation. So here's your updated chart. Okay. Some students found this confusing, so let me just break it down. The top row is common law, murder, voluntary manslaughter, and involuntary manslaughter. Okay, so the top is common law. The middle is degrees, and I put them together so you can see which ones align which. The degrees model just adds murder in the first, bless you. The rest are the same. Okay, common law, 4 types of murder. The degrees model has 5 types. Murder in the first plus the 4 that's under common law. The rest is the same as common law. So really easy to remember degrees model. Model penal code has 3 types of murder. two types of manslaughter and criminal negligence, which is the same as, negligent homicide, which has the same standard as common law involuntary manslaughter. MPC manslaughter, very different than common law voluntary manslaughter. You notice MPC, there's no voluntary or involuntary. So if you're in a model penal code jurisdiction, you should not be picking involuntary manslaughter. That is not an option. Yes?
On the mail case, it was 1987, so it was like post-existence of the model penal code, which says Barker, which includes the escape explicitly versus common law. So I guess the question is, for a common law escape, we rely on bail as that being an element?
No. Remember, these are limitations added to the common law. Only if you're told that this jurisdiction has adopted the mail rule. Okay. At common law, it's very easy. Escape, there were no limitations in terms of escape and things like that. Okay. Just had to be during the commission or attempted commission, and they read that very broadly. And mail, remember, they're applying a specific statute. They're not using model penal code. Okay, so good question. All right, so this is the chart. You need to have it memorized for the midterm. You need to know be able to rattle off all these types. You need to know what they mean, have their definitions, and how they are applied. You can create your own chart. I just did this to try to help with the discussion. You don't have to use this chart. The point is that you have some way to organize all of these. Okay, because this is all the homicide we're going to be talking about. A couple of nuances coming later in the class, but this is homicide. Week 4, we're going to start brand new crimes. So make sure before you go into these new crimes, you really have a good understanding of homicide. And we'll take our second break. I'll see you guys in 10 minutes.